Welcome to the Victims Advocate podcast, where we explore current events, crime, security, and insights into advocacy for victims of violent crime. My name is Brandon Stein, and I am the Victims Advocate.
Sharpe is facing a lawsuit filed by a woman under Jane Doe. According to NBC Sports, the 13-page civil complaint alleges that Sharpe committed assault.
Today I want to talk a little bit about the new lawsuit that's in the news against former NFL tight end and Hall of Famer Shannon Sharpe, where he has been alleged in the lawsuit for rape, sexual assault, among other allegations, in a lawsuit that was filed by attorney Tony Buzbee out of Texas. Now, this lawsuit follows several other lawsuits that we've heard in the news from pretty prominent figures when we're talking about sexual assault. I mean, whether it's P. Diddy, of course, Deshaun Watson, the NFL quarterback, Jay-Z, of which that lawsuit has since been dismissed. Tony Buzbee was the lawyer representing all of them, and he's the lawyer that has been hired. He's dismissed some lawsuits. He's settled some lawsuits. So I'm not going to sit here and comment on the credibility of any of these filings, whether they were justified or not. One thing I will say is, as a lawyer that represents victims of violent crime, victims of assault, victims of sexual battery, victims of rape, one thing that I do know is before you file a lawsuit and you assert certain allegations in a complaint, those are assumed to be true. So you need to have a good faith basis that those facts are in fact true. Now, one thing that we do know with this lawsuit is, and according to The Athletic, the Nevada woman is suing for more than $50 million. And presumably that's what's included in the lawsuit. Now, this lawsuit was filed Sunday in a Las Vegas district court by attorney Tony Buzbee. And let's just take a look at it here. Yeah, the lawsuit filed. Of course, Shannon Sharpe denies the allegations. But the lawsuit here, the complainant is Jane Doe, and according to the lawsuit, Shannon Sharpe raped Jane Doe twice, in October of 2024 and again in January of 2025. Now, when we look at these lawsuits, what's very, very important to note is that, of course, Shannon Sharpe is the key defendant here. But many times when I represent victims, what we look to is, where did the assaults happen? Where do the rapes happen? Because it's not only about going after the assailant or going after the suspected rapist or criminal. It's also property owners or proprietors who allow these types of events to occur on their property, because they also have to provide certain security measures. Now, what we hear in the news, and especially now with the Shannon Sharpe allegations, is this was a relationship that he seems to allegedly have had with this individual, and then she sues him. We don't know much of anything. What we do know is that the Buzbee law firm, they did release a statement on their Instagram account, and that statement addressed some I guess, initial statements by Shannon Sharpe, where of course he vehemently denies the allegations, denies any wrongdoing, that they're incredibly, salacious, but they're false, which we'd expect him to take that position. But when you have a lawyer, one thing you want to do is not speak out of turn and let the legal counsel do the talking. In this situation, I understand it's very, very hard, especially when you're being accused. And in Shannon Sharpe's standpoint, he's proclaiming his innocence. So if in fact that is the case, and he is innocent, and this lawsuit is baseless, it's very, very hard for someone like him in that situation to stay quiet. Because when you issue a statement and you have such a media presence and a public presence like Shannon Sharpe, what happens is everything is now under a microscope. Everything that you're saying is now evidence, and that's the problem. So when we look to this, and we look to the response, the immediate response through the media, and outside of court, there's a whole other game that's being played in terms of the media. So when we're looking at this, and we see Buzbee's statement, so he addressed on his Instagram account yesterday, April 22nd, and he really lays out what's true, maybe what's false, but what he says is that what is true is that Jane Doe never referenced any video or multiple audios that she possesses in the lawsuit. And now that Sharpe's lawyer has decided to broach this subject, they're going to address it. And there is a damning video that exists. And that's something that I guess Sharpe knew about or had anticipated to some extent, but it's really unclear what this video is. And when we look at it, the video, which would be played to a jury, is problematic for Mr. Sharpe. The video disclosed several things. Very salacious. The video is incredibly damning. That does indeed exist. So when you speak out of turn and you act on emotion, in any case, many times it comes back to bite you. And the reason being is when you hire a lawyer, the expectation is that the lawyer handles everything, not only inside the courtroom, but outside the courtroom. So now, we don't know what this video shows. We don't know how damning it is. This could also be a play on the media that the Buzbee law firm's doing. We're not sure. But what we do know is that text messages exist. We do know a video exists that, that it seems as though there was a mediation process also, according to Buzbee, that mediation process went on for more than 6 weeks. And it ultimately led to Sharpe making an incredibly significant offer to settle. So this letter, this letter that was released by Buzbee, disclosed now what may have been confidential negotiations. Obviously, he didn't disclose what number was offered, but when you enter into mediation and there's an offer to settle, it doesn't necessarily implicate you. It doesn't necessarily say that you're guilty. But the problem is, this letter is in response to comments made by Shannon Sharpe. And I could almost guarantee, even if it's not being said publicly, if I'm representing Shannon Sharpe here, I don't want him to say a word about this. Just no comment. Because any comments can trigger disastrous results potentially. And now all of a sudden, we know there was a significant offer to settle. So now the ball's back in Shannon Sharpe's court. And the questions are going to be, well, why offer to settle if you're innocent? If you're completely innocent, you've done no wrong, why are you offering a settlement money? So when we look at cases like this, and we look at the lawyer that's representing him, he's no different than what I do. And what I know is that any case I take, you really have to substantiate the allegations, especially if it's involving the lawsuit against a public figure. Now, with these types of assaults that occur, the ones that come into the news are the ones involving public figures. Jay-Z, P. Diddy, even Deshaun Watson. All those involve, of course, public figures, but where did those assaults occur? For instance, the Deshaun Watson were all massage related as far as I know, and the allegations that were raised, as far as I know to be true, and what I've heard, relate to his inappropriate conduct during those sessions. A question I can have, and many people have, well, where was it happening? Was it happening in his house? Was it happening at a therapy facility? Now, in the event that something like that happens at a therapy facility, then do you hold the therapy facility liable? Do they do something wrong there? have they done something to result in this type of conduct from occurring? But, getting back to the Shannon Sharpe situation, it's obviously unsettling when you see and you hear about those allegations, and you see the number that's been presented in the lawsuit of $50 million, and when you have sexual assault allegations. Now, when you file these lawsuits, it also has implications for his career and Shannon Sharpe's career, because in the event that this lawsuit's baseless, in the event that something comes out that this Jane Doe is fabricating something, not telling the truth, lying about things, that's extremely problematic, not only for the Jane Doe, but for Buzbee. Because what then happens is what we're dealing with the Jay-Z case, and in the Jay-Z case, it appears that Jay-Z did file a countersuit against Tony Buzbee for defamation and extortion. Now let's talk about those two things. First, defamation, defaming someone's character. Now, in order for a defamation suit really to have some teeth, the person filing has to be, in all likelihood, a public figure. Jay-Z fits that bill. So when you're looking at a defamation lawsuit that was filed against Buzbee, when we look at that, Jay-Z is essentially saying, hey, look, you filed this lawsuit against me, you dragged my name through the mud, and now I'm coming back at you because this lawsuit you filed was baseless, or whatever Jay-Z's allegations are in the complaint. Now, the risk that you have as a lawyer when you file these lawsuits, not the defamation side, but these sexual assault lawsuits, is if you're going after a public figure and you're wrong, there are grave consequences, not only for your client, but for you individually. And there's liability that you bear. Because now with this defamation lawsuit, now Tony Buzbee has to lawyer up himself and defend it. And then you have claims of extortion. Now when we look at the extortion, it's quite simple. Extorting someone for financial gain. And that's what it seems to be occurring in this case, where obviously Jay-Z was accused, allegations were made, it was made public, and I'm sure there were demands made by Buzbee to try to get a settlement and make everything go away. And then when the lawsuit went away, Jay-Z said, well, wait a minute, not only did you defame me, not only did you drag me through the mud, but you also tried to extort me. You tried to get money out of my pocket that I've earned for the benefit of your client. So I'm going to sue you for that as well, and I'm going to claim damages for that as well. So now all of a sudden the tables have turned. So when we look at Buzbee and these filings, the newest one was Shannon Sharpe, it's a Jane Doe plaintiff. Now, I also have come across plenty of victims that don't want to use their name. And a lot of times it happens in some very, very sensitive cases where either their name is removed for initials, or it's just a Jane Doe or John Doe, a fake name, because all this is public record. Every filing is public record. That's how the media finds out about it. That's how we find out about the allegations. So also when you have a Jane Doe, it shouldn't raise the implication that, hey, it's a baseless lawsuit because she is not using her real name. It's quite the contrary. When you've dealt with trauma, and I've had many, many clients, many victims that I've advocated for that have dealt with trauma, and they don't want their name out there. They want their initials. They don't want it public, but they know they need justice, and I need to get them justice. So using the Jane Doe is not the biggest deal in the world. It's actually quite common, especially in these sexual assault, rape type of cases. It's very, very common, especially when the party on the other side is an incredibly public figure, such as Shannon Sharpe. So, when we look at this, and this lawsuit was just filed a few days ago, obviously you have to see how it plays out, and the process is so slow, and the media cycle so fast. So if I was advising Shannon Sharpe, I'd tell him, hey, just go about your business, keep your mouth shut, it's a pending legal case, and that's all you comment on. Because when push comes to shove, if you keep starting to put out statements and starting to allow this to build and build and build, you keep the story in the media. At some point, you just got to shut up and keep your mouth shut and let the legal process play out. Because ultimately, what can happen is, whether you're liable or not for this, you could still settle the case to make it go away, and it's called a business decision. That happens all the time as well, where it's not an admission of fault, it's not an admission of guilt. It's you're paying an amount to have it go away, because one thing that you don't want to do is, if you dig your heels in the sand in a case like this, and you let the process go on, I think it was filed in Nevada court, all of a sudden that case is pushing, and you have your deposition taken where you have to give sworn testimony. It's not just getting in front of an iPhone in front of the media and putting out a story or a presentation about, your side of things. Now you're under oath, and that's a problem, because what happens from there, if you still continue to dig your heels and not want to make this thing go away, you end up in trial. And unless if certain motions are filed, and I don't know if this was in federal court. I'm not sure if this was in federal court or not. Federal court, there are no cameras in the courtroom, but in state court, as we saw in the OJ case, for instance, cameras are permitted. Sometimes you could file a motion to make the proceedings private for certain reasons, safety reasons or what have you. But in a situation like this, the one risk that you run if you're Shannon Sharpe and you want to dig your heels is, hey, look, I'm going to dig my heels. I'm innocent, but at some point in time, there's going to be a jury of my peers that are randomly selected. It could be 6 jurors who are going to be listening to evidence, listening to testimony, listening to your testimony, Jane Doe's testimony, seeing these text messages, seeing these videos, and those 6 random people decide your fate. And that's the problem. Because how are you qualified to be a juror? What's the vetting process? Well, you need to have a driver's license, essentially. That's what it is. I'm in the state of Florida, and what I tell all my clients, I say, hey, look, you could settle a case, but if you want to go to trial, it's within your right, and we try cases all day, every day, and that's fine. But the problem you run is that it's not a judge deciding your case, it's a jury. And the only prerequisite to sitting on a jury is, hey, do you have a driver's license? You live in the county, you live in the state of Florida? All right, come on in. You're a part of the jury pool. And then 6 random people decide your fate, and then when they decide your fate, it's public. And if they decide that you're liable, and the threshold to be liable in a civil case is much less than a criminal case, the burden is not beyond a reasonable doubt, like it is in a criminal case like we saw with OJ. That's not the situation in civil, so it's a lot easier to be found liable in a civil case. So you have some decisions to make, and that needs to be behind closed doors, not through the media, not in front of a camera, but with your lawyers and your legal team. Because when you make those decisions to settle, it's a business decision. And for me, as representing victims of violent crime, victims of crime who get injured, victims of any accident, any injury, usually what happens? It does settle. Most cases do settle. And when they settle, in the settlement documents, there's language in there that, hey, this is not an admission of guilt. This is confidential. And that's what happened to Deshaun Watson. A lot of those cases were settled confidentially. We don't know what they were settled for. And just because they were settled doesn't mean Deshaun Watson was liable. It just means, hey, look, it's a business decision. I'll pay a little bit to make this process go away. He may have been 100% innocent on those 23, 24, however many claims that there were. But he wanted to make him go away and focus on football. I don't know. So for Shannon Sharpe, it's going to be a long process. You got to allow it to play out. And unless there's some court ruling adjudicating that the allegations are frivolous and they dismiss the case, or there's no evidence to substantiate the claim or what have you, it's going to be pushed through. And it's best to stay quiet and just allow the process to play out, because every time you speak, there's going to be a lawyer on the other side who's going to want to comment and put out a long letter like we saw Buzbee put out, with some salacious things in there when we're talking about videos or text messages, and the fact that there was a mediation already and an offer were conveyed and there were attempts to settle. You don't want that in the public. Absolutely not. You know, so for those reasons, it's very, very important to keep your mouth shut, especially if you're a defendant in a certainly in a criminal lawsuit, but even a civil lawsuit. So look, we'll see what's going to happen, but it should be interesting playing out, because of course, you know, there are some serious allegations here, and we're dealing with you know, a Hall of Fame baseball player, football player.
Thank you for joining us. I'm Brandon Stein, and I am the victim's advocate. Your voice matters, and if you or someone you know needs representation, visit steinlaw.com or victimadvocate.com for more information. See you next time.